Hi, I'm Scott Grinelli. I'm one of the partners here at Polsky, Schuldeis and Rosen. I've been practicing workers' compensation for approximately 30 years, 25 of which I've spent at this firm. I am the partner who's in charge of two different districts, namely the Brooklyn district and the Hauppauge district. And I'm also the partner who deals the most with medical issues. And that's actually why I'm here today, to talk to you a little bit about medical treatment, the medical process, and the medical authorization process. We hear all the time from our clients about how difficult it is to obtain treatment. And we understand it, and we feel your pain, believe us, and we try to expedite that issue as best as possible um, uh, through the board's process for getting medical treatment authorized. For a little bit of background, about 14 or 15 years ago, the board made a tremendous change to the way medical treatment was handled. It used to be that we would walk into a hearing, for those of you that have been through them, and we would simply ask the judge for whatever treatment was being requested. For example, a doctor might say they wanted chiropractic care 3 times a week for 8 weeks. We'd ask the judge, maybe we would negotiate something, but we would walk out of the hearing with a specific authorization because we got to explain it directly to the judge. We got to tell the judge about your case, about your injuries, and about the need for that kind of treatment. Unfortunately, as I said, about 14, 15 years ago, the board changed that process completely. And they created a portal. Well, they created two different things. First, they created guidelines regarding treatment. And those guidelines regarding treatment are just that. They're a book of pre-authorized medical care. And basically, they cover a progression of treatment from the most basic, least invasive process like physical therapy, all the way through things like surgery. And those are all pre-authorized. But those are all things that you have to meet the criteria of those guidelines to be able to get done. In theory, the process was created to allow the doctors to get more immediate care for the injured worker. The faster the physical therapy was provided, the more you're able to recover, the more you're able to go back to work and return back to a gainful employment. Um, in reality, while it does allow for immediate care, the further you get away from your date of accident, the system has now been created so as to prevent you from getting active care as we go down the road. And that's a fight that we end up having to have all the time with the judges and with the insurance companies. So they created this standard of care, and each body part literally has a book, and I've got them all right here, literally has a book that tells you what type of treatment you can do under workers' compensation. And your doctor is supposed to open up that book and look at your condition and say, okay, yep, you meet criteria X, Y, and Z, and therefore we can go ahead and do physical therapy. Once you've used up the care that's in that book, now the doctor has to start using a separate process called the PAR process. And essentially, that is the doctor talking directly to the insurance company and asking for authorization for treatment. And that's where things get a little bit hairier. And that's where we try to get involved as much as we can, although the board wouldn't like us to be involved in it too much. They have created a portal, a computer system, a telephone system between the insurance company and the doctor. And the doctor fills out a form online. That form goes to the insurance company. And now the insurance company has certain timelines in which to answer a request. The doctor sends a request in for whatever it is they want. Once received by the insurance company, they have 15 days, 15 days to respond without getting you examined or having your records reviewed, or 30 days if you're examined and you have your records reviewed. At level 1, that's the first level of review of the request. Doctor sends the request in for physical therapy. Level 1 is the examiner themselves, and they either say yes or no. Obviously, if they say yes, it's nice and easy. You can go ahead and do the physical therapy that's authorized. If they say no, it immediately escalates to level 2. Level 2 is the insurance company's medical expert. It could be a nurse manager, it could be a physician, it could be a number of different medical professionals who review the request and issue their decision. That level 2 is often where things end. Because when they're denied at level 2, there are certain processes to get them to level 3 or to get them in front of a judge. And if they're not covered within a time period, it can be a problem. If they're denied at level 2 and the doctor requests review, and they have a very short period of time in which to do so. It's on the form itself, and it gives the doctor about a week or so. If the doctor asks for review, it goes to level 3. Level 3 is the Workers' Compensation Board's medical arbitration unit, and they too review the request and issue their decision as to whether or not you need the treatment. Assuming the treatment is denied either at level 3 or at level 2 without any further review, that's when we can finally become involved. And that's when we can ask for the judge to take a look at the request and make a decision. If necessary, sometimes we have to litigate that issue, especially when it comes to more invasive actions like surgery or similar types of treatment, where we have to ask to go in front of a judge, take testimony from a doctor or doctors, depending on how many are involved, and have the judge make a decision. If we're successful, the insurance company has the right to appeal. If the insurance company is successful, we have the right to appeal. What frustrates our clients and us as well is the obvious. There is a huge amount of time that has to elapse through each one of these steps. You have at least 15 days that you have to wait for your first request to be answered. And quite often, because it's denied, it has to go through a couple of different levels and then go to medical arbitration. And when it goes to medical arbitration, that takes a while too. And then you have the appeal or a rebuttal and a response from the board. And that can take an extensive period of time. And unfortunately, the way the system is created, the doctors can't provide the treatment and hope that they're going to get paid retroactively. They have to wait and they have to see. And that's why we find our clients are very frustrated about the situation. And that's why they come to us, because we can help expedite things. We call the carriers, we talk to the carriers about how you need whatever it is the doctor is requesting. And as I said before, maybe we can negotiate something where we are able to get some of what the doctor wants, but not everything. Sometimes we can push the case to get to the point of arbitration, or we can push the case to get it on the calendar. Because if we don't ask for a hearing, the court won't give us a hearing. They're happy to let the request just lapse away and go away, and perhaps there won't be another request. And of course, we litigate these cases and we fight these cases out in front of the judge in the hopes of getting the judge to authorize the treatment that you need in order to recover, get back to work, and move on with your life outside of workers' compensation. So I hope I've given you a little bit of insight into the MG2 process. I've got these great books here. If anybody wants to read them, they're great. Every body part you want. If you have any questions at all, feel free to give us a call, email, whatever you want. We're happy to direct you a little bit more about the PAR process, about workers' compensation as a whole, and anything else you might need help with. So thank you.